Hey, I'm Danny Black, joined by Paul Lesko for another episode of Hobby News Daily. What's going on, Paul?
Thanks for having me on. I think it's gonna be fun. We got a couple things going on in the hobby, and it's always exciting, and it's especially exciting recently.
Well, the good news is I called all the judges involved in the cases to find out when you would be the busiest, and then I tried to schedule you for that time. So
Nice,
I appreciate you squeezing in.
thank you.
Um, so for those who don't know you beyond Twitter, and don't know your background, you grew up in Chicago and you now live in the St. Louis area.
That's correct. That's correct. So I grew up in Chicago in the '80s. I should have collected Jordan, and I completely whiffed and did not.
No,
So
you am I correct? You were a Dwight Gooden guy.
I was. That is exactly why I did not collect Jordan. I was focused solely on Dwight Gooden. I have a great Dwight Gooden collection from the '80s. I just don't have any of Jordan from that same time frame.
I was a dealer back in the '90s, and I had tons of, Ken Griffey Jr. Upper Deck rookie cards, and I had like two Jordan rookies in low condition or something. I was like, the basketball cards will never be worth anything. Let me have 150 of these Griffies. That'll, So,
No,
yeah.
no. I mean, we should. We fell because I think at that time Topps had the NBA license, and they're like, nah, let's just let that lapse. This will never be worth anything.
Well, people forget that the '86 was the return of the basketball card. Not that I'm totally tangenting already, but so it was like, okay, let's see if anybody cares.
People did.
They still do, it turns out. So,
Yeah.
that being said, if anybody wants a Ken Griffey Jr. Upper Deck, give me a call. I want to talk about your practicing law, how it relates to the hobby. And I want you to define IP because it's relevant to you and to the hobby. So give everybody just a little bit of an explanation about what you do in the courtroom, out of the courtroom, and what the term IP means.
Sure. So I started my career. I've got a technical background, so I got funneled into intellectual property. That's what IP stands for. It's patents, trademarks, copyrights. It's any type of property that's really not tangible, but gives rights to the people that own it. So pretty quickly, with trading cards, I was a collector in the '80s, took a little break, got back to collecting in the 2000s, never looked back after that. I noticed really quickly that trading cards have a lot of intellectual property on them. I mean, everyone's familiar with the copyright notices, the trademark notices, the rights of publicity. And so there was a real overlap between what I was practicing and what I was collecting. And that's what really gave rise to focus my collection from wasting money on prospecting, where I struck out on everything, to actually start collecting cards that had legal issues or were involved in lawsuits. And that it really helps, not only my collection, but I think also me as an attorney, because that way I can explain to people why I got the cards, displaying in my office. People ask, I can tell them why the cards are cool, but I can also tell them the legal issues behind it, what happened in court cases, and try and explain the issues to them. And it becomes a practice for me actually in the courtroom. I spend most of my time as a litigator. I spend most of my time in the courtroom, which means I have to explain complex legal concepts and complex technological concepts, not only to a judge, but to the jury. So if I can explain my collection or my interests to Twitter and hopefully get people to understand that, those are the same people that'll be in the jury. So it's got to practice there, talk on Twitter, make sure people understand it so that when I'm actually back in front of a jury, I can explain them, hopefully, and they can understand and rule in my client's favor.
I never thought about it, but Twitter's the world's best editor.
It really is. I mean, and it's I think it's the best source of what a potential jury is. You got a bunch of people really a bunch of really angry people with really short tempers, and somehow you have to turn them to your side.
With short attention spans.
That also, yeah. I had a thread yesterday. It was quite long, but I put a TLDR at the end that was 2 or 3 tweets after that, and people were giving me shit over that. And like, that's too long. I'm like, okay, 500 characters. I'm sorry.
Yeah, I was about to say Twitter's nothing compared to the briefs you were reading.
It's true. Yeah, try to summarize a 44-page brief over 7 different claims. It's it's gonna have more than one tweet.
You can't do that in 140 characters?
I probably could. You're in trouble.
Right. Panini is F. I mean, you're talking about what's going on right now, and just to give people a sense, and I think they get lost because we have a headline here, a headline there, and it almost mirrors the real world. We become numb to it. There's things are popping up, all over the place. It becomes washed over as everybody's suing everybody. Well, that's kind of true. Yep. But specifically, Panini's involved in like 6 cases, major cases. Yep. I mean, not even counting redemption cases and the good old fashioned stuff that used to seem so innocent, and all that fun. But then you have Fanatics. You've got cases that were recently settled, and it seems like it's snowballing.
Yeah, no.
The bigger the companies are, the more litigious they get. Is there a truth to that?
It's this year I'd say it's been aberrational. Normally you'll have 4 or 5 lawsuits filed every year. This year, I mean, I think we've had 12 or 13 lawsuits already filed, and you already have lawsuits that were already pending. There's just been a lot of movement this year, and it's happened before. When I started covering the hobby in 2011, there were a lot of lawsuits back then. Then Upper Deck was the ringleader. Upper Deck was the one that was named in every single lawsuit, either as a plaintiff or a defendant. So it's just cyclical. I think everybody gets involved in lawsuits, especially when you have the industry kind of being reset. When you have the powers are changing, you have the new people coming in, trying to solidify themselves. You got the old people going out, trying to grasp at straws. You got other people trying to come in. So I think it's just the current history of where we are right now. That's why you're seeing a lot more litigation. I'd be surprised if 2 years from now we were back to maybe only 2 or 3 lawsuits, because everybody will have been tired and they're made their attorneys rich enough already.
I was about to say, or they won't exist.
Yeah. That too.
I think there's a direct correlation between lawsuits and mergers and acquisitions. I'm not sure who's the chicken and who's the egg, but
yeah. It's easier if you just buy us.
Right. Yeah. Well, I'd like to lower the price, so let me sue you and take all your executives, and
Exactly.
Hypothetically, allegedly, hypothetically. If you could give us kind of from your perspective, and I hate saying that, the 40,000-foot view, I like to go 10,000 feet higher than everybody else, by the way. What do you see as actually the most pertinent cases? Because as much as the WWE license is topical, I don't know in the grand scheme of things that it competes with some of the Panini Fanatics stuff. Am I right? Am I wrong? How do you look at the most pertinent cases to the hobby?
So this is unique where we are right now, because if you look at the easy one that jumps out more is the Panini versus Fanatics antitrust case. That is certainly the largest case that's out there, because Panini is basically asking for a giant reset button to be hit. They're asking for Fanatics to make sure to spin Topps back off to where it was, to spin off the manufacturer that or the printing company back. So they're kind of asking for a giant reset button. So if you're looking at, what's the biggest case out there, that's it. However, all the other Panini and Fanatics cases between them that are going on, as well as Panini versus the NFLPA and WWE versus Panini, they're kind of, part of the same giant octopus that is this case, because they're all interrelated. Because, issues that show up with, potentially is the WWE contract, the license with Panini, is that still valid? That directly affects the Fanatics antitrust case, as well as the NFLPA, the alleged stealing of their employees, the unfair competition claims from Fanatics at Panini. So if you kind of look at the Fanatics antitrust case, it's kind of a super group, and everything else is coming out of that. So that's, I think, is the most important case that's out there, not just because of the effects it could have, but because of the sheer number of other issues, contracts, unfair competition, antitrust. There's so much there. It's definitely the biggest case out there.
So, as a small example, let's say that Panini loses the WWE case and the license reverts to Fanatics immediately. Now you're looking at the Fanatics antitrust case. That would actually help Panini because that will show that Fanatics has now added another license and added more to their monopoly or monopolistic operations. Would that be a way to look at it?
It's going to be weird. It's almost the opposite because the Panini antitrust lawsuit, where you have to focus for an antitrust lawsuit is you have to define what is the market. And what I always point to for that is, remember, the federal government allowed Sirius and XM to merge. They were really the only two providers of satellite radio. But they pointed out to the government, hey, our actual true competitors are podcasts. And they're so much larger than us. So they allowed them to merge. Here, Panini is suing Fanatics and saying that there's 8 different markets that Fanatics is potentially committing antitrust in, and it's high end and low end basketball cards, high end and low end NBA or NFL cards, MLB cards. It's a crazy way that they've divided everything up. Fanatics hasn't said what they think the market is, but I think what they're going to say is it's all trading cards, not just sports, but entertainment and TCGs. So really, when you think about the WWE lawsuit, it actually helps that more comprehensive view of what the market actually is, because WWE is, it's sports entertainment. It's not necessarily a sport. And one of the issues in the WWE case is that Panini did not create its own TCG, its own trading card game, and that contractually they were required. So it kind of shows that, not just that, it's not just sports cards, it's not just NBA cards. It might be all cards. And I think that really makes sense because with the Lorcana lawsuits going on, if we talk about that, I've actually spent some money on Lorcana cards. And in doing so, I'm buying less baseball cards because I have a fixed amount of revenue that I'm going to spend on cards. So that shows that for me, for a consumer like me, the market is all types of trading cards. And then if you reset the market that way, Fanatics, might not even have market power when it's going up against Pokemon and Disney and other companies that are like that. So that's, I figure that's what Fanatics will argue. But then on the flip side, you're exactly right. Panini's going to be like, look at these guys. They've got NBA, they've got MLB, they've got NFL, and now look at them. They've got wrestling, But, there's also the hypocrisy in that if you just flip the cards. Well, Panini, you had WWE, you had NFL, you had NBA. You're really just arguing that, now Fanatics has MLB also. So it was not an antitrust when we had 5/6 of everything, but now that they've got 6/6, that's totally antitrust. So
fascinating. There's a couple terms that have come up, and I just want to make sure that people who follow you and are following the hobby cases are familiar with these terms and just the impact on the cases. So let's start with and we talked about IP, but let's start with the TRO.
Yeah. So in the Panini in the WWE versus Panini case, WWE moved for a temporary restraining order. What that is, you're basically asking the judge, hey, judge, I know we just started this case, but I'm being hurt so badly right now. You need to rule in my favor before we even get into discovery, before anything else happens, because otherwise I could go out of business or something could happen to me that's just, so bad that money won't make it whole. It's very difficult to get. You not only have to show that you're likely to win, you have to show that you're being irreparably harmed in a way that money, can't make you whole. So that's what a temporary restraining order really is. It's saying, hey, judge, let them know that we're going to win from the beginning going into this case. They're very difficult to get. They don't happen very often. And as the news showed yesterday, WWE was not successful in getting a TRO against Panini.
Cease and desist.
Yeah. So cease and desist is it's outside of the courtroom. It's when typically an intellectual property holder finds an infringer that's out there and says, hey, stop what you're doing. If you stop what you're doing, maybe I won't sue you. And invariably, most cease and desists, that's how they work. It's kind of a, friendly reach out before I sue you to stop doing what you're doing, and then maybe I won't sue you.
And this is going to be the hardest one, because I think this is essentially why there's a case. But in not all of them, but in most of these, we're hearing breach of contract.
Yeah.
Okay.
So
what is a breach, and how do you prove a breach?
Yeah. So breach of contract is, it's why, especially when you have contracts with such large companies, they'll have like 30-page, 40-page contracts outlining every potential in and out. A breach of contract is basically one party's failure to abide by the terms of a contract. So to put it into perspective, for the Panini WWE case, WWE is alleging that Panini needed to make a trading card game and needed to sell digital trading cards. And they're pointing to parts of the contract that say, hey, you need to make those. So you're in breach. You didn't make those. Therefore, you're in breach, and you owe us money, and you need to stop using our licenses. So it's basically a breach of contract. Generally, is we had an agreement, you breached the agreement.
And the TRO is basically saying it's such a terrible situation for us that we feel it needs to stop immediately before we even get through the case.
Exactly. And for it's easier to get a TRO for a case when you have a licensee like Panini using WWE intellectual property. Here I'm bringing all the terms in all together here, but because what happens is, really, according to this contract, Panini is allowed to make cards using WWE's trademarks and WWE's copyrights. Well, if Panini is in breach and WWE has terminated the contract, but Panini keeps making cards using WWE's IP, well, it's kind of like Panini's hijacked. And I'm going to keep making stuff and keep making cards with your trademarks, even though it's your property. I'm going to keep doing that. And that's kind of the theme that WWE had. Panini's response, however, to that was, we didn't breach the contract. The contract is still in place. We have permission to use your IP, and that's what we're doing. And that's what the long fight will be in court right now for that case.
If I'm correct, it was summer of last year was the deadline for the wrestling cards and NFTs, or digital cards, I should say. Let me take that back. A digital card and a physical card.
That's correct. And it's kind of a complex little matter. It's all complex contract.
Yeah. Explain where we are now. And now the TRO was denied, where are we moving forward?
Sure. So the allegations of breach are that so the contract between WWE and Panini went into effect in, I think, like March or April of 2022. According to that contract, within 3 months of the contract beginning, Panini needed to make certain product categories. Trading cards, obviously, stickers, but then also in there were a trading card game and digital trading cards. And the contract said, if within 3 months, if you are not making all of these categories, you are in breach and we can terminate the contract. And that's the basis of this lawsuit. However, you'll notice there's a time discrepancy here, where the breach allegedly occurred in June of 2022. And according to Panini, and it seems also confirmed by WWE, WWE never complained about it until August of 2023, 15 months later, when WWE said, hey, not only are you in breach, we're not going to give you the opportunity to cure, to make it better. We're just going to cancel the entire contract. You need to stop making cards. And oh, by the way, you owe us $5.625 million, because that's what you would have paid us over the contract as the minimums. So after the denial of the TRO, that's really where we are, is focusing on, was there a breach? And if there was a breach, did WWE wait too long? Because Panini's saying, hey, you waived that opportunity. You needed to tell us we were in breach 90 days, 3 months into the contract. You didn't. We went for a year. We gave you millions of dollars of royalties. We allegedly tripled the royalties from the last licensee, which was Topps. And so, you missed your window. And because of that, if we were in breach, we are no longer in breach. And that's going to be the tough issue that the judge or jury is going to have to decide.
a couple of things, and they might be coincidences. And these are these are all Danny's ideas, to be clear. WWE and UFC merged and became TKO as a corporation. Just slightly ahead of this, it became a much larger entity. I don't know if that had any impact on choosing whether or not to go after a larger entity in one case as opposed to battling two, but it seems certainly the timing seems way too coincidental. As you said, there's a discrepancy on the longer timeline. So why now? I guess it becomes the next question. And so that's my first thought is that just doesn't seem to. It seems coincidental, and I don't believe in coincidences. Mm-hmm. The other thing is the Fanatics Panini is really a timeline fight because those licenses are transferring eventually anyway. Mm-hmm. So isn't that really just a fight on timeline for who's going to profit on these last year or two before the licenses transfer?
It really is. Except for the antitrust case, which is kind of asking for a reset to have Top spin out so that Panini can actually get into the ring back again and try and get these licenses. But you're exactly right. A good way to look at what would make Fanatics happiest is if Panini's licenses end early, and apparently with the NFLPA and WWE, they would also be happiest if the Panini licenses would end early and Fanatics would get it too. So that's a really good way of looking at the lawsuits. Panini wants to hold on to it for as long as possible and maybe extend it, and Fanatics would like Panini to just go away. And it looks like there were discussions between Fanatics and Panini. Apparently, Fanatics put in an offer for Panini to accelerate their licenses. Fanatics was going to pay Panini to take over those licenses, but that didn't work out, and that's what gave rise to actually Fanatics' lawsuit against Panini. So there's so many lawsuits. I almost feel like there needs to be like a complex, one of those conspiracy boards back there with lines going back from Post-it notes and stuff, except it's in real life.
I have it off camera. You just can't see it.
Perfect. Good. You'll have to show me so I can get it straight in my head.
I don't have it straight at all. That's why I'm talking to you. I'm moving all sorts of pins when we're done. So how about the WWE, TKO, UFC? Does having them merge as one company affect suing them at all? Does it change two separate contracts, or was it under one umbrella? I'm a little bit confused about how that affects the lawsuits.
Yeah, at least at this point, I mainly focus on what are we looking at that's filed in courts, and it really doesn't here, especially if you look at the allegations of why the alleged breach occurred between Panini and WWE. It wasn't like the NFLPA breach, alleged breach there. They're saying that was something, if I'm remembering right, had something to do with a change in managers, right? Some managers left Panini and went somewhere else. So that's why the NFLPA said that there was a breach. So that, had that been an allegation of why WWE brought their lawsuit, then maybe that would carry over and say, hey, maybe UFC, maybe there's a breach there too. But the alleged WWE breach is very specific. And unless the UFC contract also required trading card games or digital cards, and those weren't provided, at least as of now, it's more of we're just going to change the name of the plaintiff and defendant in this case, and shouldn't really have a substantive change to the case itself.
Okay. I was just curious because they seem to go hand in hand.
Things may change. I mean, that's the beautiful thing about discovery in cases. We may find out more. And I mean, that's what I'm looking forward to in the WWE case is if I'm Panini, I'm asking questions like, why did it take you 15 months? What took you so long? Let's get all their executives up. Let's ask them all the questions. And when did you first notice? I mean, they're going to ask, when did you first notice the breach? And regardless of when that, if they first noticed the breach 90 days into it and they did nothing, that's great for their case. It's like, why did you do nothing? What did you talk about? And if the breach occurred much later, maybe somebody fell asleep at the wheel. Maybe it's, maybe somebody who was supposed to be monitoring this just didn't do their job for a long time and then woke up one day and said, oh, I forgot about trading cards. Right. Trading card games. Oh, no.
Well, and I think that's interesting, actually, that they call it trading card game.
Yeah.
Now, is that in the hobby? We call trading card games non-sports. It's Pokemon and stuff like that. When they call it trading card games, is that what they're referring to, a true game, or does that mean traditional sport card like we think of it for players?
So they have a specific definition in the contract for what a trading card game is, and it's basically the use of, it's summarize it, but it's basically the use of cards that are mainly collectible in having some type of game mechanism that's utilized with them. So it's a murky definition, but you could tell that the focus really was try to get like a Pokemon or a Slam Attack. I don't remember the name of the Tops game that they have in Europe for soccer, if it's Slam Attacks or something like that, but they have a TCG out there. It's something
Match Attacks, something like that.
Yeah. And that's really what they're focusing on, because Panini is saying, hey, we complied with that because every convention we go to, we have card wars and pack wars, box wars and pack wars that you can enter into. And we advertise that, come in with your WWE cards, buy them from us, and we will have pack wars. They're saying that is actually a trading card game. So the court will eventually sort that out. I think the reading of it is that the best reading of the contract was that the trading card game has to be a standalone product and can't really be a service, that's actually happening at a convention. But, I think the definition is murky enough right now that, gives both sides something to argue to the judge and jury about.
So let's talk about the cool stuff.
The cool stuff. The legal issues.
It's all cool. It's all cool. But now, to me, this is like my dream. You've actually been involved in some of these cases. I know Dr. Beckett's talked about serving as an expert witness umpteen times. At some point, you have to get people in the hobby involved to actually talk about what we're discussing and what it means to the hobby. Is that right? And in what role, for whatever you can talk about, have you served?
So I as you can imagine, I get lots of questions from people in the hobby, especially with legal questions. Most times I try to steer them to work it out outside of court, because even though I'm a litigator for the past almost 19 years, I've been a plaintiff's litigator. So I'm the one that starts the lawsuits. I'm the one that starts the shit, Yep. And as much as I enjoy doing that, I still counsel my clients beforehand that litigation is difficult. It's hard. You're going to be high one day, you're going to be low the next day. And judges and juries are people. You may have a lawsuit that you think is 100% of a winner, and you're still going to lose it. It's just how it happens. So I think the scariest thing for Panini and Fanatics about their lawsuits is ultimately you're going to have 6 total strangers make a business decision for 2 multi-billion-dollar companies. I mean, that is scary. So I mainly, when I get information like this, I try to counsel people into working things out. And I've been lucky so far. Most people that have sought me out, we've been able to work stuff out without filing litigation.
Well, I was once told the expression, the second you enter the courtroom, you've already lost. And what's the stat? 99% of the cases are not settled in the courtroom; they're settled outside the courtroom.
That's about right. It really is, because if you look at trial, I mean, I've been out for 24 years. I've been practicing law for 24 years. I think I've had 4 or 5 trials. I mean, they are definitely the exceptions to the rule, and I've filed hundreds, if not 1,000 or more cases. And I've rejected 10 times that easily. I've rejected 10 times that. So getting to trial is the exception to the rule. And it's not just for, the parties get together and settle it. Courts have good mechanisms for getting rid of weaker cases, either through motions to dismiss or summary judgment as well. So it's, yeah. And cases really aren't the lottery tickets that people think they are. For every wild card case that we heard about, the Stat Smasher case where they got, $20 million or whatever from Panini, there's a bunch of other cases where they, the companies fought for 3 years, 4 years, and the settlement is a walk away. Both sides, you just wasted $2 million each of attorney's fees, and nothing got resolved.
In the antitrust case, I want to clarify this, because you alluded to that being maybe the largest thing that can impact the hobby. If there is a reset, and a reset being Fanatics basically goes backwards in time, and we go back to more of the way things were before they took the license.
Mm-hmm.
It seems far-fetched that would happen.
Yeah.
That seems like a little bit more of a Hail Mary. However, can you talk about some potential pitfalls that might be legitimate points for Panini?
So there, I always look at, and you mentioned it earlier, maybe been offline, but sometimes lawsuits are negotiations more than anything else. And this could be we did know that Fanatics and Panini were talking. Fanatics wanted Panini to accelerate the licenses, so it could be more of a, hey, you need to give us, Panini could be saying, hey, you need to chip in some more money here. We want to sell you this stuff, but you weren't going to give us enough money. So we're going to tie you up with, these 3 lawsuits here. And, just you can either pay your lawyers, we could fight this out, or you could pay us now. But then on the flip side, Fanatics is like, okay, well, or we can pay you less because we're going to sue you too. And look, you just happen to be losing some licensees at the same time. So you're actually not worth as much because those 2 licenses have already been accelerated to us. So now there's less for us to even, buy off of you. So it might be, when it comes to the actual legal issues of who has the strengths and the weaknesses might not even matter. It might just be a giant multiple year long contract negotiation or buyout negotiation.
I don't see any way that hits a courtroom, just to be clear to everybody watching. That's my opinion. Your thoughts?
I would love it. I'm colored by the fact that I would love to see it hit the courtroom with such big issues like that and big stakes. That's why I was really enjoying the, yesterday the TRO hearing was going on in the WWE and Panini case. And I was hitting refresh on my computer just over and over and over again, because there could have been some real big stakes there, because had WWE succeeded, all eyes would have been on, okay, what are the wordings of that TRO? I mean, is Panini allowed to make some WWE cards? Can it get rid of its inventory? Is it even allowed to send out redemptions? And it's a much smaller case than the antitrust case. So if you can imagine from my perspective, if Panini would win that antitrust case, wow, the wording of that order would be, yes, is it going to be a reset, or is it just money? Or is it something less? Or do they have to give them a contract back? It's just, there's so many possibilities, and there's just, you just want to see what's happening there.
If that happened, it'd be the biggest thing in the hobby legally, I think, since Fleer went to the Supreme Court.
Yeah, no, it really would be. And it's that case, was, the original breaking up of the original monopoly in the hobby. Trading cards were, cute little, toys back then. And, it was a big case back then, but it was not the multi-billion-dollar business that it is now. That's on TV. It's on Netflix. It's getting pretty big out there.
You've been very generous, and we're crossing half an hour here. So I do want to try to make up some time in the air before we land. If moving forward, let's say the Panini and the antitrust that gets negotiated out, we don't have a reset. Fanatics moving forward is going to control, like you said, 6 out of 6 or whatever the number is. In general, what does that look like for the hobby? From a perspective moving forward. Is everybody else on non-licensed products essentially? Except for Upper Deck and hockey, and some European. Is that really what we're looking at?
It seems like that would be that way. You're gonna. It's. I think Fanatics. I'm trying to remember the exact language that they used. They're saying, basically, this isn't really changing the hobby. There was one licensee before us. There is one licensee now. There will be one licensee in the future. So we're, gone are the great days of the 80s when we had 4 or 5 different licensed products. We are truly in an era where there's just going to be one licensee. And so even though it seems like it's a big reset, it's really just Fanatics' turn to be the licensee. And, if that doesn't work out, well, it looks like you can see the licensors do know that they have legal rights, and maybe they could try and accelerate things to the next company that comes around. So I don't think it'll change much of how it is. I think we'll see a lot more, as Panini calls them, pajama cards,
Yeah.
where you have, cards with players that don't have trademarks or, the team logos and stuff like that. I think we'll be seeing a lot more of that. And that's the thing. It's, the company that could figure out how to make pajama cards sexy. I mean, there's a real potential market in that.
Leaf has fought.
Yeah. Yeah.
I don't, they're distant, compared to Topps, Fanatics, and Panini. They're a distant third, I would think. But I think they've, my personal thoughts on them aside, they've done a pretty good job.
Yeah, no, I think they are too. And it's just, I think there is, I'm not a graphic design guy, but I think there is some way for somebody to make, pajama cards or just cards out of uniform. There's a way to make them sexy. I mean, keep thinking of the Mariano Rivera rookie card, well, that might be the ugliest card in the world. It's still, it shows there is an idea.
The pleats on those pants will live in infamy.
I mean, I look at that card, I just think of Miami Vice and how much I love watching Don Johnson just driving around.
When I go shopping for khakis, when I see those pleats, the first thing I think of is Mariano Rivera. And then I remember that my waist size is probably a lot of the numbers bigger than his. So. Okay, so you touched on this before. I think people want to know redemptions. It's been a problem in the hobby. People have sued about redemptions on their own before any of these other lawsuits have come in. I mean, it's gotten to court before. It's not clear what's going to happen, is my understanding. Is that where we are just in general in redemptions? And legally, how do you look at redemptions in a normally? I mean, is an IOU okay? Is a substitution okay? How do you see that legally?
Yeah, I'll tackle that last one first because, I always like being a true lawyer. I like everything as papered out as possible. I would like manufacturers to put like a paragraph on the back of every card saying, hey, we are really trying to get you everything, including the autographs, but you have to understand athletes are busy. So sometimes we can't give you what we say we're going to give you, and you have a chance of getting a redemption, but we were going to try like heck to make sure that we get you those. I think every box should have something like that so the consumers know what they're getting. And that's what has given rise really to the big lawsuit out there for redemptions, which is funny. If we didn't have all these Fanatics and Panini lawsuits, I think the big focus would be on the Panini redemption lawsuit, which is one that we've kind of forgotten about. That's going to trial next year about whether Panini's redemption process was legal or not. Because in that case, we learned there were some years that Panini was issuing 25% of their redemptions were not being fulfilled. They were being substituted. And yet Panini was still continuing to sell their cards with the redemptions. And it's one of those things where had Panini put on there, hey, we really suck at fulfilling redemptions right now. 25% of you aren't even getting the card. They would be fine. That would have been perfect because people would have known what they're getting. But instead, now we've got a trial that's going to happen. Hopefully that case doesn't settle. I really want to see that. And we might get a little bit of, legislative, judicial guidance as to what does a redemption program, a legal redemption program need to look like. And it's so far, it's been a tough case. It's been a long case, but since it is going to a jury, the judge is saying there's potentially something here. The jury will decide whether these were legal redemptions, legal substitutions or not.
As somebody who used to prospect on players, I know you did, and I love doing it as well. Is there an aspect to that in the redemptions that get people fired up because the player is so hot when they pull the card and they could have sold it then, and by the time they get it, the guy flames out. I mean, if they were making money on redemptions, people wouldn't be complaining.
Yeah, no, that's really the big issue from a collector standpoint is, Panini took 7 years to fulfill this redemption, because most prospects aren't going to do anything. So, had I had that redemption actually in hand, I could have gone to eBay. I could have sold it for $3,000 and now it's worth $3. So, and that'll be, another one of those interesting issues in the case. What are the damages? because, technically that card is now worth $3. So should Panini have to pay $3? Should it have to pay $3,000? So both sides will get experts that'll talk about how to value these cards. Now, in Panini's favor, the Panini redemption lawsuit is not a class action, meaning that it's not going to be a blanket recovery if the plaintiffs win for everybody in the hobby. There's only 2 plaintiffs. There's only like 5 or 6 cards at issue. And I think most of the cards, if not all the cards, are worth under $100. So it's going to be, a confined holding. But, it gives you guidance as to, if you have redemptions, if you feel that you've been harmed, maybe you need to, take advantage of it. Go to small claims court, try to do something.
I was about to say, if they find in favor of the plaintiff there, you could look at your stopwatch to find the attorney who's going to be putting together a class action.
Well, the judge already denied a class action. So the parties did try to get it to a class action, and the judge said this is not a class action.
And you don't think somebody would try to bring one if it was found, or are they not able to bring?
I think they'd lose because the class action status also went up to the Court of Appeals, and the Court of Appeals affirmed the judge's decision there. So I guarantee you
That's fascinating why they wouldn't allow a class action on that, especially when you're talking about 25% in a year.
Yeah, I'm baffled by that ruling. The judge really didn't provide reasoning for it. The plaintiffs had to poke at the judge.
So no guidance.
Yeah, to even get some reasoning for it, and it made no sense to me. I thought it was going to be certified as a class, so Panini really won that one. But having the plaintiff's firm I used to work at, if there was cases where you couldn't get a class, well, then what you do is you file what's called a mass action. You just sign up, 1,000 people, 10,000 people, and you file 10,000 lawsuits, or if there's arbitrations, 10,000 arbitrations. And that way you basically get the same effect, although I think a lot of companies don't think it through. If you have someone who successfully mounts a mass action, you're going to pay more than you would for a class action because at least as a class action, everybody's consolidated. You have a chance of getting a lower settlement. But if you have 10,000 people each individually wanting to hit a home run, you're going to have some actors that are there that have unrealistic view of their cards and won't settle for anything less than $1 billion. So.
Well, my mother many years ago did defense work on asbestos, and it was one of those where she met with hundreds and hundreds of separate defendants, and each individual person was their own case. Yeah. And I can only imagine if each redemption had to prove their own case, and the nightmare that would be.
Yeah, no, at least with mesothelioma, for those cases, it's just, okay, I have a doctor's diagnosis. Okay, now we just move right on to money. Here, okay, well, your redemption came in at this day. Okay, well, we have to figure out, did you submit it right? Did you do this? What was the player's value? I mean,
as a good defense attorney, I would also ask how many packs of cigarettes were you smoking when you worked there, but
Exactly. Yeah. No, that's true. That's true. So, but yeah, we'll see what happens. But it is pretty funny that would be the largest lawsuit out there right now if it wasn't for the other 9.
It's like, other than that, how was the play, Mrs. Lincoln?
Yeah, exactly.
All right, Paul, I don't want to overstay my welcome, but I'd love to have you back again. I mean, I could do hours with you on this, on or offline. I truly enjoy this, and you're absolutely the best in the hobby at it.
Oh, I appreciate it. Thank you. And this is fun. And definitely, I'll definitely want to come back on. And, maybe next time we'll be talking about how, it was funny when Fanatics and Panini used to be the largest lawsuit in the hobby. We now have this one out there.
Right. If it wasn't for this, that antitrust would be pretty big.
Exactly.
All right. Hang out in the green room for 30 seconds. To everybody else, thanks for watching. And make sure you check out hobbynewsdaily.com. New articles every day. Fresh podcast every morning, and emails every week. See you later.